Welcome back for our last session on benefits of the Judgments Convention to cross-border dealings. We're honored to have with us on stage our moderator for this session, Dr. James Ning, Commissioner of the Inclusive Dispute Avoidance and Resolution Office of the Department of Justice of Hong Kong, along with our distinguished speakers, Dr. Thomas So, Dr. Ning ZHAO, and Dr. Marcelo de NARDI. I will hand it over to Dr. Ding now, please.
Thank you. Good afternoon. Welcome back to the last sessions of this conference. And we have a panel of distinguished speakers, and it's a panel full of doctors. So we'll try to fix anything outstanding from the rest of today's conference. Our first speakers will be Dr. Ning ZHAO. She is from the Permanent Bureau. Many of you know her very well, so I do not need to introduce her. And she is responsible for the judgment projects, and I would say that the successful conclusion of these conventions is very much her very hard work. So Ning will tell us about some special features about these conventions, and in particular the benefits of the convention to cross-border dealings. And after that, we will hear from Dr. Marcelo de NARDI and Dr. Thomas So. So maybe without further ado, I will invite Ning to the stage.
Thank you. Thank you for your kind introduction. I'm very honored to be here and to talk about the Judgment Convention now, which is really dear to my heart. Before doing that, I would like to also to thank the People's Republic of China and the Department of Justice of Hong Kong HCCH for organizing. We co-organized this fantastic event. You cannot imagine within 2 months to prepare such a high-level conference, how much work they have put into. So thank you very much. I really appreciate. So what I'm going to talk about is, like we have heard a lot this morning and early afternoon about this convention, about the structure, about the goal, and about the features. So what I would like to do and intend to do is to look at the convention from a different perspective, which means where the certainty and the flexibility have been meet together in order to facilitate the recognition and enforcement of judgment, which is the goal that a convention is trying to pursue. So we start with a state of play to see what is current outside there for the recognition and enforcement. So one sentence, there's no global framework or regime for the mutual recognition and enforcement there until the Judgment Convention. And what exists right now actually is a patchwork. So national law and bilateral treaties, for example, trans-Tasman agreements between New Zealand and Australia. There's also agreements, arrangements, for example, we heard today, the China mainland with Hong Kong. And also there are like international or supranational like agreements. For example, we heard like Brussels I regulation. We know there are also like Minsk Convention and Las Linas Protocol. So those are the framework that are available for the recognition and enforcement of foreign judgments. So what is the impact now is for a national court who receive application for recognition and enforcement, they first look at is there a bilateral treaties? So if no, they look at the national law. So in general, we talk about national law, we said, okay, the rules are diverse. So first we talk about the attitude. So some regimes are very open to foreign judgment, some are very close, some are just in the middle. So those are the attitudes. So if we look at the mechanism for the recognition enforcement, so we know there are reciprocity. So again, there are 2 types of reciprocity. So we talk about one is factual, which means country A will recognize and enforce foreign judgment if state B has already recognized A's judgment. So there's another one is presumed reciprocity, which means A will recognize B's judgment with a presumption that B will not refuse A's judgment. So they are already different. Then we also heard today there are common law rules. Again, common law rules is different. So the foreign judgment will be used as evidence in originating the process. So the foreign judgment then it become evidence as a debt owing to the person. So what are the outcome? So outcome simply the recognition enforcement. There's no recognition enforcement or partial recognition enforcement. For example, under common law system, common law jurisdictions, there's no recognition enforcement of non-monetary judgment. So there are some outcomes that will be re-litigation. So what does it mean for the parties? There's no certainty because a party will not know what to do with the judgment. Is the judgment going to be recognized and enforced in other countries? So is the judgment meaningful relief? And there's also inefficient if the party need to re-litigate the dispute. So it will be costly, will be time-consuming. That can you imagine? There probably will be a contradict judgment, which brings the risk for the parties. And in fact, those ineffective judgments cannot be recognized and enforced abroad, or its practical effectiveness cannot be recognized and enforced, will reduce access to justice. So what does it mean for the cross-border dealings? With the lack of a global framework and the international trade, business, and investment or globalization will be obstructed. So as what we heard this morning when Kara Noss quoted, so it is the most significant pitfall of cross-border commercial litigation. In fact, as also we heard this morning, in this era of globalization, and the movement of the peoples and movement of goods, services will all increase. So there will be more connections, more interactivities of persons and business, which means more litigations, which means there will be more possibilities for the recognition and enforcement of foreign judgment. So, excuse me. So there is a genuine and urgent need for the global framework for the recognition and enforcement of foreign judgment. So here we go, then we got the convention. Then what is our convention, the 2019 HCCH Judgment Convention? I don't want to repeat it because we have heard that for the whole day. But how this convention will achieve the aim, which enhancing recognition, access to justice and promoting the international trade and investment. So we can see, for example, then the parties will obtain a meaningful judgment. So the judgment will be recognized and enforced abroad, so as to reduce duplicate proceedings, as such reduce cost and time frame for obtaining foreign judgment, obtaining the recognition and enforcement of foreign judgment. Then it will also allow the parties, for example, even in the face of making litigation strategy, will take into consideration of the possibility of recognizing enforcing judgment abroad. So in making informed choices, and the last one is improving accessibility of law. So it is then possible for parties, their advisors, and also, of course, the judges who need to decide cases. They can just go into one set of the law instead of the patchwork of different laws. How does our convention benefit the cross-border dealings? So I think as a whole, through the establishment of the global framework we just talked about, as it also it contains a set of commonly accepted rules, so which make it easier and possible for states to join the convention. And some of the rules are very novel, as we already heard today, and there's also a wider application of the convention. So for more specifically, it also try to achieve these aims, achieve the benefits for the cross-border dealings through a balanced set of rules, ensuring certainty, efficiency, and flexibility. Flexibility here taking into account the state sovereignty and the public interest involved. So when this morning, Professor Kay already said the convention has a moderate application of the scope of application. So now I would like to look different perspective of how wider scope of application of the convention. It's not contradicting, it's just from a different perspective. So the convention applies, judgment should be on the merits, and which should be enforceable and effective in the court of origin, in the state of origin. So it containing monetary and non-monetary judgments, so for the common law countries, and including court orders. So the court orders including the fee for the lawyers. So I think it's very important for the practitioner to know that. Then arising from the cross-border dealings and contracts, so including consumer employment contract. So my colleague Marcelo will talk about that later on. Then also tort, property, trust, and in the context of both on-land dispute as well as off-land dispute, the traditional ones, and including collective redress, default judgment, and judicial settlement. Those judicial settlements, which means approved in front of court or concluded in front of court, as long as they are enforceable in the state of origin. And the certainty here, actually I just pick up some key elements that the convention will provide certainty and predictability. So those are the examples. For example, the key obligation and the fundamental element of the convention is judgments covered by the convention should be recognized and enforced in other contracting states. So the second one is no review of merits. Then third one, because we have been repeating today, so I just try to go faster. So the refusal can only be based on those grounds specified under the convention. But the last one I want to draw your attention is recognition shall not be refused on the ground that recognition enforcement should be sought in another state. So that is a novelty in this convention. It is more sort of a forum of non-convenience in the context of the recognition of enforcement. Then another certainty provided is regarding the procedure of the recognition and enforcement. So it should be governed by the law of the requested state. And then for the judicial filters, so when deciding the eligibility of a judgment for the convention, so there are jurisdictional filters need to be applied. So the convention provides an exhaustive list, so a list of judicial filters for the convention. So it provides certainty for the party to know as long as the filters are met, there's a possibility for the recognition enforcement. But when talk about jurisdictional filters, I can't stop telling you that the convention does not deal with national rules of international jurisdiction. So from the perspective of efficiency and effectiveness the convention can provide, so first, I think this allows for severable part of the judgment for recognition enforcement. So the judgment is severable and enforceable and effective. I mean, the severable part is effective and enforceable in the state of origin and also fulfill the jurisdiction filters of the convention. Then the several part of the convention, it will be eligible for the recognition enforcement. That's what Article 9 says. Then another one I would like to draw your attention is also the novelty of the convention. This morning, Marcos already talked about that. It's a no security for the recognition enforcement on the solely grounds of nationality and residence of the judgment creditor. So the rule, this novelty was introduced with the purpose of to relieve the burden of the judgment creditor and also for a quick and effective circulation of the judgment so as to enhance access to justice. When talk about the no security rule, I just want to add one element. So on balance, because this rule was supposed to be more advantageous to the judgment creditor. So, but on balance, the same article, Article 14, paragraph 2, and then protect the judgment debtor. So if the judgment creditor fails the application, then the court orders granted in favor of judgment debtor can be circulated under the convention, even though that court orders is not based on the merits, because we haven't talked about the judgment on the convention should be based on the merits, but this is an exception. So the purpose is to protect the judgment debtor. And another I want to draw your attention is also one of the novelty of the convention. So, but there are two circumstances, as Professor Jiang also talked about that. So there are the two circumstances where the recognition and enforcement can be refused, is refused and postponed, but the judgment and the application can still be made afterwards. So the first situation is when the judgment is subject to review, or the time limit for seeking ordinary review has not expired in the state of origin. So that is the novelty of the convention, which in a way does not require the judgment to be final and conclusive. So this purpose is also in order to speed up the recognition and enforcement process to be more efficient. Then the second circumstance is the least pendants rule in the context of recognition and the enforcement. So which means there's a parallel proceedings at the requested state between the same parties on the same subject matter, where the court of the requested state was seized before the court of origin, which means seized first, and there's a close connection between the dispute and the requested state. So that's the two circumstances. Then the convention also have the recommended form, which will be recommended to be filled up by the state of origin or the court of origin, in order to speed up the procedure and the recognition enforcement. So that's another mechanism to promote efficiency under the convention. And I have to say, I should mention here that the recommended form is not binding. It's still being revised, so will be ready soon. Here I just highlight in red the novelty of the convention. Happy for you to read afterwards. Okay, for the flexibility. So there are two perspectives. So flexibility was introduced either for the facilitating the recognition and enforcement of the judgment. The other is to cater for the state sovereignty and public interest. So for the first one, I want to I listed four for your information. For the first one, I think it's also the most important one is, as we also heard today, is the convention does not prevent recognition and enforcement based on national law except Article 6. So this mechanism, this rule allows those states who have a liberal recognition and enforcement system regime to still be able to recognize and enforce foreign judgments. As we already heard today, I think Professor Peter Nielsen mentioned that the convention lays down a floor, not a ceiling, for the recognition and enforcement. And then we also heard today that there's no mandatory ground for refusal. So the convention keep on using may for the recognition, for the refusal. And Article 4.1 provides 13 different grounds for jurisdictional filters. So they are all alternative to each other. And again, allows for the severable part of the judgment. So for state sovereignty and public interest involved, so the convention allows state to declare not to apply the convention to domestic cases. We also colleagues mentioned today, so it's the rule already in the 2005 Church Court Convention, which means in addition to the court of origin, all elements of the case, all relationship between the parties, all connected to the requested state. So because some countries will consider such cases it's not international. So in order to make it possible, the convention says okay, they can make a declaration if it's needed. And for the countries, for states who have strong interest to particular subject matters, the convention also make possibility and to make a declaration not to apply the convention to those matters. And another one is a judgment pertaining to the states. States can declare to exclude the convention to judgments which arose from proceedings to which a party, a government agency of that state, or a neutral person acting for them, for the state, was a party, even though the judgments relate to the civil or commercial matters. And the last one, and we also heard last panel, is punitive damages. So it also is different wording. It's not a declaration, but it's that the convention allows the state or the court to decide if the damages which is non-compensatory, they may refuse the recognition enforcement. So now we see, just briefly see the certainty for specified ground for refusal, but they are not mandatory for application. So there are definite jurisdiction filters in the convention. There are also alternative jurisdictional filters. So there's no security rule, which is a novelty in the convention, but the convention allows the state to make a declaration to this rule. Now, another part is how we try to make a balance between the certainty and the flexibility. So the uniform interpretation of the convention will serve as a bridge between these two elements. So the convention itself provides the rules, and then we heard, especially last panel, they keep on talking about the uniform interpretation. I totally agree. Then with the uniform interpretation, the court should look at that when interpreting this term, they should look at the operation, the goals of the convention is trying to facilitate the recognition and enforcement. They should also consider the concept, an international concept, rather than national interpretation of certain rules. So with that, plus explanatory report, which is still being revised, thanks to Professor Gracie Martin and Professor Sommet. They work really hard on the explanatory report. Even though the report itself is not binding, once it's ready, it's not binding, but they provide very good information and details of discussion why certain rules have come to that place. So it provides useful information for the judges, for the parties, and for practitioners, for the states as well, I think, for reference. So my concluding remark here. So the convention itself is a package for the facilitating the recognition and enforcement, but it does contain novelty rules, like we said, no security rules. The convention also contains rules to serve different purposes: equal treatment of parties, protecting public interest, protecting weaker parties. So all those elements putting together, so the convention strikes a fine and sound balance between certainty and flexibility, so as to facilitate the recognition and enforcement, so as to encourage the state to join the convention. As such, it will also benefit individuals, individuals' business, I think even for states, for the better benefits for the cross-border dealings as a whole. As we also just heard from Christina and others, and we also say there's another role that the convention can play is to serve as a model for bilateral or regional arrangement or even national law reform, so which in an indirect way to benefit the cross-border dealings. So the last sentence I would like to use is the convention is and will be a game changer in international dispute resolution, benefiting cross-border dealings as a whole. Okay, thank you for your time. Thank you.
Thank you, Ning, for giving us an overview of the conventions, the benefit of the conventions. On the one hand, it gives certainty and predictability to business, traders, and litigants. And at the same time, it also provides flexibility to the government and to the court and the contracting states. Our second speaker will be Dr. NARDI. Marcelo has already spoken this morning, so he will need no introductions. I think he's the only speaker who speaks twice at this conference, so we are very honored to have him. And he will focus on the protections for consumer and employees under the conventions. Marcelo.
Hey, good afternoon. Thank you again for the honor of being here. Thank you, James, for chairing this. Thank you, colleagues, for sharing this moment. I would like to address this particular thing. Maybe this came to attention of the organizer due to a paper that I prepared for the Special Commission works. And this is a subject, mainly the consumer subject, is a subject that I study since my PhD studies. and I'm an actual practitioner as a judge in this subject. The employee part of this is not something that I'm really in deep, but is connected to the two things are connected in the convention, as we learned from Emma's speech this morning. And by the way, Emma just killed 80% of what I prepared today. So I'll try to extend the part of it that is more specific. And thank you, Emma, for doing the difficult part of this. Okay, let's see what's left for that. So I'll try to speak on the model relationships on consumer situations and the employee situations, more in depth on the consumers that I control more. Try to address the indirect basis of jurisdiction, limitation to protect the consumer and employee. This is what Emma has talked about this morning, so we won't take that much. And the general refusal allowances and consumer and employee protection, some of that Peter Nielsen has addressed also. So there's not much left, as you may say. There is a question at the end that might be provocative for you. So the relationships on consumer situations, what is the model that the convention provided for us? There's the first sentence is brought from the actual convention. So it's a natural person. Natural person is an essential concept that would be related to consumers. So this was debated at the Special Commission, and most of members present at that time came to the conclusion that limitation to natural person is adequate for the purposes of the convention. And the second part of it is not that all natural persons, but natural persons acting primarily for personal, family, or household purposes. Not all the activities of a natural person is connected to this convention to be stated as a consumer. So this is really, really important. Since the view of consumer situations, at least on the Brazilian view, and I can tell you that with the help of Marcos, Argentina and Paraguay, maybe Uruguay is more closer to this concept nowadays, but Argentina and Paraguay is more closer to Brazilian view on this, that doesn't limit the consumer situations to these ones, personal, family, or household purposes. So these are two limitations very important to be understood for us to comprehend or understand the protection of consumers under the future convention. In matters relating to a consumer contract. So this is the last limitation and was addressed by Emma. The relationship, the model relationship is a model of contractual relationship, not an expanded relationship that might be understood under Brazilian law, to say, that covers other kinds of relationships. So this limitation makes me remember the linoleum cases that is famous on this subject that came from Germany. That was a person in a fabric shop, and she entered that for exchange of money or asking for some information not related to the actual business ongoing down there. And this person was hurt by a linoleum roll of fabric that fell from the shelf, and this person sought for recovery of damages. And this is a situation that could be classified, at least under Brazilian law, would be classified as a consumer relationship, not a contractual relationship. Unfortunately, in Brazil, we have other kinds of situations, model situations for this, at least on academic level. We have a very unfortunate accident happened in a shopping center, a shopping mall, something like what they call in Europe the passages that goes from one street to the other. And people use there as a shortcut for all the going from work to home or something like that, not actually entertaining the participation on the business ongoing down there on those shops. And unfortunately, that shopping mall, that mall, came to a very large explosion on gas and hurt a lot of people within the stores, entertaining contractual relationships with the business, the shops there, and also those people just passing by for the shortcuts, not entertaining contractual relationships. So this led me and led Brazilian delegation to sustain the need for diverting from the consumer contract modeling, but this was not well acknowledged by the plenary at the Special Commission, and we came to this model that's kind of restrictive in a manner to say. So we have these two concepts, main concepts. This is a natural person, not all situations related for personal, family, or household purposes, and matters relating to a consumer contract. This is the situation that would provide for protection under the future, the actual convention. So these are the three bullet points that I would get from that concept, and I will tell you something after this on what is not covered by the protection that conventions gives to consumers. Well, of course, legal entities in opposition of natural person. Legal entities would not entertain the protection that the consumers, natural person, entertain. So this would lead to some small business buying a machine that will not be directly applied to the actual business, to say the selling of fabric, and there is a copy machine that does not work, and this legal entity, the businessman, or tries to seek for a recovery of damages against the supplier, the seller, and loses the case, and is debtor, comes to that debtor for costs of proceedings. And this legal entity will be subject to circulation, international circulation of this judgment without the protection of the consumer provisions in Article 5.2. So this is the situation that very different from Brazilian perspective, and of course Argentinian and Paraguayan situations that really is different for us. Natural person acting on behalf of a natural person not relating to this family. This is the very frequent case that is the gift. You buy something and give as a gift to a friend, not relatives. So this might generate a case of costs proceedings that will not entertain the protection that the convention allows. And this is quite a situation that should, on a moral thinking of the content of the rule, that should be much more protected than the one that a national person working or dealing with its own purposes. So this is a situation not covered by the protection, and if a natural person loses a case on this situation, will be the subject of the free circulation of the judgment. Similar to that, natural person that benefits from or is harmed by the product or service and is not directly related to the supplier. This is the third person, similar to the case of the linoleum rolls or the Passage case, the said Passage case in Brazil. This is something that, on a moral understanding of the rule, should be also protected, but there is no protection directly from the provision on Article 5.2 on this situation. And the other situation that I managed to list is a natural person acting for professional purposes not directly related to the product or service provided. These are the cases of the small business or the physician or the dentist that works and use some kind of equipment not related to the actual practice. So this, and of course the attorneys that would not be covered by the protection on these cases. So we can imagine this case of trying to seek relief for damages against the seller, and also the case of not paying for the product or service, and the seller coming after the consumer for the payment of the service of the things, and this will not be covered by the protection of the convention. So on the matter of employment, the model situation would be, it's expressed down there, and I copy that. An employee in matters relating to the employee's contract of employment. It's also a contractual view, to my understanding, and also to, with limitations to Brazilian understanding, the labor contracts, mostly the employment contracts, mostly are viewed as a contractual relationship, but a very limited contractual law applied to this kind of contracts. It's a very controlled contract, at least in Brazil. So the modeling that is applied here by the convention is for the individual employment contract. So when the employee can understand and the employer can understand that there is an individual relationship, even though there is a lot of employees in that business. So the employer has a lot of, say, thousands of employees, but every one of them could understand the employment contract as individual one. As opposition to that, we have the collective contract, and this poses some kind of trouble to understand the provisions of the convention, because in Brazil, for example, there is an understanding that the collective contract, even though that might not seem or resemble an employment contract, traditional one, the collective contract is supposed to be an employment contract also. And there are other figures, other situations in other countries that would be very much more difficult to understand. And Paco, Professor Garcia Martin, the co-rapporteur, just mentioned one situation in Spain where the national law of Spain would not consider a collective labor contract as an employment contract, and thus there would be a problem of qualification of the situation to entertain this particular protective situation. And there are also more complex employment contracts that are involved with parallel contracts. And the model of this, in Brazil at least, is the live in the household contract parallel to the individual labor contract. And this is quite common in Brazil, not anymore, but it was for years now. It was a very common situation, and it should be very common situation on those kinds of contracts for infrastructure that we mentioned before in this event. When you have to allocate employees in different places for a period of time to conduct construction, for example. It is very similar. So you have a parallel contracts to provide for homes, to provide for supplies on food and stuff like that, transportation. And this kind of parallel contracts doesn't seem to be quite fitting in the protection of the convention, since it is quite limited to the individual contract model. So how does the convention protect consumer and employees? The idea of Article 5.2 is to remove the alternative or cumulative or parallel indirect basis of jurisdiction, the jurisdictional filters, some of them from the applicability to consumers against consumers and employees. This is how the convention protects consumer and employees. Okay, so these two phrases tries to capture the idea. All basis of jurisdiction, all jurisdictional filters applies to against suppliers and sellers and employers, and a few bases, a few filters applies to consumers and employees. What does this make? This makes that once the consumer or the employee gets judgment in his favor, the seller or the employer is the debtor, he can use the convention for circulation in a free basis without any concern of being the nature of the relationship of consumer or of employment. On the other hand, if the judgment is against the consumer or the employee, then the limitations of the basis of jurisdiction appear and try to prevent the circulation when the consumer or the employee is supposed to have less resources for his defense. This is the idea underlying the protection of the convention. I will not go in deep on the contents of this. Emma has listed the relevant jurisdictional filters. I'll address this like habitual residence and express submission, a limited and very specialized submission that would be provided by the consumer and the employee. It's right behind the judge, behind the court, expressed behind the court. This prevents the two situations of the not expressed submission, tacit submission, and also removes the possibility of any kind of choice of forum, choice of court. So this is the kind of protection that the convention gives to consumer and employees. And this is sufficient. In a general view, of course not. The protection for consumers and employees depends on substantive law. And we understand that the convention provides for what it's made for. And everyone that passed here has said what it's made for and how does it work. It works allowing and facilitating the circulation of foreign judgments. This is how it works. And in this subject, the particular effect of the convention, it provides for the protection of consumer and employees through this limitation of applicable jurisdictional filters. So no contractual forum and no choice of court are the bottom lines of this. So refusals, fraud, service of failure, general cause of refusal. Let me say that order public, public order or public policy, yeah, is the word there. Ordem pública for us. And that would be the general protection applied, at least in Brazil. Okay, Brazil would resort to this general refusal to protect consumers and employees under the circulation of foreign judgments. We have a few cases in employment, very, very few cases on consumers from foreign judgments coming to Brazil. Now, coming to an end, let me ask you a question that came to me in preparation for this event. Can recognition enforcement under national law, Article 15, allow for judgments against consumers or employees to be recognized or enforced? Do you understand that Professor Nielsen has told us the convention is the floor, is the less that a contractor state can do to recognize and enforce. The state can do more. But can a state recognize and enforce something in favor of a seller or an employer. That was against a consumer and an employee under national law. This is my question to you. I'm trying to answer this. This is rolling on my brain here, and I don't have quite a direct response for this. But first of all, maybe. Well, at least I have the doubt. Okay. In a logical understanding of the thing, I can construe a thinking of it that could be the outcome of the relationship between 5.2, 5.1, and the 15, that this outcome could be attained. But what if this situation, well, really happens? I can construe an interpretation that the protection of Article 5.2 would not allow for this, but it's not expressed down there. So this situation will lead to the use of public policy clause, would lead for any kind of other, rounding attempts, but that might be the outcome, maybe not envisaged by us in the preparation of the convention. So my first impression is that we can have an interpretation that this can be prevented under the convention, but it's not directly stated down there. The second thought, convention doesn't make it worse. The actual thing that is happening now is that under national law, on that particular case, the sentence, the judgment would be recognized and enforced, and the convention doesn't make it worse. But on the long run, on the envisaged long life of effectiveness of enforce of this convention, that would pose the problem that the convention contains, so suggests certain level of protection of consumers and employers, and this situation might not be covered, at least directly, by the convention. So my first answer to this question is I can construe an interpretation, but it's not expressed, stated on there. So with this, thank you very much for the honor of being here for the second time. Right.
Thank you, Marcelo, for giving us some insights on the consumer and employee protection under the conventions, and which is a very nice supplement or extension of Emma's presentation this morning. And his last slide gave us a very interesting questions that may be a subject for discussion in a future special commissions on the judgment conventions. Our last speaker on the panel is Dr. Thomas So. Thomas is a very experienced litigator and also a past president of the Law Society of Hong Kong. And his presentation will focus on the benefits of the conventions for promotion of rule-based international trade and investment. Thomas, please.
Thank you, James. Good afternoon, ladies and gentlemen. It's not always easy to be the very last speaker. But my job is to keep everybody awake in the last 15 minutes. So as a practicing lawyer, I would like to take the following 15 minutes speaking topic in this way. Being a lawyer, we represent clients in cross-border dispute. So the way how I propose to talk in my next 15 minutes is how do an investor, how do a client who have a cross-border dispute look at this judgment convention, and how do we see the convention? Do we see it helpful, or are there areas that we see need further improvement in order to win more users? Because after all, the judgment convention is there to help people, to facilitate them to enforce a judgment across a border. So that is the first angle that I propose that I will look at. And then second, I would compare in a bird's eye view the judgment convention with the mainland Hong Kong arrangement, because you probably have heard from our Secretary of Justice early this morning that early this year, Hong Kong has signed an arrangement with the mainland court under which we have agreed a mechanism where we would recognize and enforce a civil and commercial court judgment between the two jurisdictions. It's very much similar, so I would like to also take some time to do a comparison between the two, and that would then conclude my 15 minutes presentation. Now, cross-border dispute, as I said, looking from the client perspective, first of all, we look at two courts. First set of court is the adjudicating court, the court that you want that forum to decide your dispute and give you a win or a lose decision. The second level of court is the enforcement court, which deals with the product of the first level of court and take it further to enforce it in jurisdiction where you want to enforce it. So the first level court, the resolution bit, what do clients see from this level court? What do they want? The client normally will ask you, how long does it take? How much does it cost? How likely am I going to win? Right? So objectively, time, cost, fair and transparent proceedings are the crucial factors that an investor will look at the first level court. Second, whether or not that court that an investor wants to choose as to adjudicating court is a court that has jurisdiction to hear that matter. That depends on local law, that depends on whether you have an agreement to submit to jurisdiction and everything, right? Then we go to the products of the first level court. Once you have gone through an adjudicating process, you have a product, you call it an award, you call it a court judgment, and then the next question is, how do you going to do about it? Where to enforce this court? Now, from an investor's, cross-border investor's perspective, normally we talk about money, a payment of a judgment sum. Then you locate the assets. Where around the world are you able to find assets belonging to a judgment debtor, and where can you efficiently recover the amount of judgment that you have obtained from the adjudicating court? Then the second question the client will ask, all right, if looking at it from a global perspective, you may be able to locate 5 or 6 jurisdictions where there are assets belonging to the judgment debtor, then you ask the next question, how long does it take? How much does it cost? Is it transparent? Is it a fair proceedings when you go to that court to enforce your judgment in order to choose which jurisdiction you want to go to? Right. Then finally, it's very important, is movement of funds. There is no use if you can successfully enforce a judgment in a certain jurisdiction when you cannot or have a lot of difficulty, or it takes a long time for you to move those funds away from that jurisdiction back to where you want to receive it. So those are the very crucial factors that an investor would look at. Now, having gone through that checklist, we then look at the judgment convention. Okay. What does it mean to an investor that I have just described to you? A client that is considering to sue in a cross-border dispute. The judgment convention to them is a bridge. It bridges the collaboration between the adjudicating court and the enforcement court. Okay. That is all, if you ask me, that it brings the distance between the adjudicating court and the enforcement court closer. By looking at the judgment convention, it kind of tied the different courts from different jurisdictions closer. And it facilitates the issue where to enforce. Just now I described that. When you got a judgment from a given jurisdiction, you want to go to a jurisdiction where you want to enforce it, and you have asked the questions that I have just posed to you. Okay. And then the judgment convention helps to facilitate, to answer a lot of questions to the investors. First, most importantly, is to resolve the issue of jurisdiction. Because first, Without a convention, normally you look at the local law, you look at a lot of questions about whether the court has jurisdiction, and also you have to consider from the enforcement court's perspective whether or not the enforcement court considers the adjudicating court actually has a jurisdiction to hear that matter. Now, with the convention, you have a set of rules where the parties to the convention from different countries come to a consensus as to what they regard as prima facie, we regard an adjudicating court to have the jurisdiction. Okay? That is a very important matter because based on the judgment convention, the adjudicating court, if taken by the investor to choose that place as the place to adjudicate the dispute, and then go to another jurisdiction to enforce it, but where both states or both countries are signatory to the convention, the adjudicating court will be taken to have the jurisdiction of that particular dispute, okay, by the enforcement court. And once you have that judgment given by that adjudicating court under the convention, you go to an enforcement court. The enforcement court will not reopen the merits of the dispute. Okay? They only look at the procedural matter. Now that is very, very different from a situation where you do not have a convention, because you might be able to have, I will move to that second stage where you have competing jurisdiction between different courts, where different courts may have jurisdiction over the same dispute. Now, grounds for refusing to recognize enforcement, we have heard that many times today, so I don't want to bore everybody. I just want to divide it into two parts. The first part, we call it the usual suspect, all right? Because if we do international litigation, international jurisdiction, these are the usual suspect under the grounds of refusal, meaning the jurisdiction, natural justice, whether notice has been given, whether opportunity has been given to be heard, and all that. Fraud, public policy, you have heard a lot of that. Those are the usual suspects, so I don't want to waste your time, right? Second part is where you have competing jurisdiction between adjudicating court and the enforcement court. Now that is quite important, I think, from people like us who do international litigation, because more than once you might find a dispute where a client comes to you. You can actually choose more than one or more than two courts, arguably have jurisdiction. Then you have to advise your client which court they should go to. And that is very, very relevant when it comes to the enforcement aspect. So that is important. When you look at Article 7, okay, I summarize it into two angles. Under Article 7, the time when the court sees of the matter, meaning the adjudicating court, when does the court get seize of that matter, and when does the judgment come out? The timing is very important under Article 7. So if you look at Article 7, when an enforcement court receives a request from a requesting court, from the adjudicating court, for example, from the adjudicating court asking the enforcement court to enforce a judgment, there are grounds for refusal. One, if the enforcement court finds out that in the enforcement court jurisdiction there is an earlier judgment than the adjudicating court, then they can refuse. Or the enforcement court finds out that the enforcement court has got seize of the same matter, they can also either refuse or postpone. Okay. So that is quite important from the practitioner's standpoint when you are advising a client right from the outset, right from day one, as to where to sue and where to enforce. The timing is very important, right? Okay, so that is Article 7. Now, many of you familiar with the choice of court agreement will remember that the choice of court convention has a provision where you have an exclusive jurisdiction clause. One court would agree to suspend proceedings. But here, in this judgment convention, there isn't such a provision. So you still have a possibility where you may have parallel proceedings, okay, running through the procedure. But then at the end of the day, it's the timing that matters. So that's Article 7. And then flexibility and enforcement you have heard, so I don't want to repeat. Good thing about the Judgment Convention is it allows severability. You can sever a judgment and you can have a settlement reached through the court where you actually do not have a judgment based on merit, but you have a settlement sanctioned by the court. You can still rely on Article 11 of the Judgment Convention to enforce that. Now, going to the arrangement on the reciprocal recognition and enforcement of judgment in civil and commercial matters signed between the Court of the Mainland and that of Hong Kong. This was signed early this year, 18th of January. There are altogether 31 articles. Now, in the Judgment Convention, there are 32 articles. And if you take time to look at this arrangement, it's modeled basically on the Judgment Convention. And I would like to compare that very briefly. Right? Judgment Convention Article 1 talks about exclusion. The Arrangement Article 3 talks about exclusion. Judgment Convention Article 5 talks about the 13 types of situation where you can presume that there is jurisdiction. Article 11 of the arrangement talks about jurisdiction, also the same. Have 6 scenarios where adjudicating court is presumed to have jurisdiction. Then Article 7 of the Judgment Convention talk about refusal. Article 12 of the arrangement talk about refusal, almost identical. The wordings are almost identical. So what I'm trying to do here is that whilst we're talking about international recognition of judgment between different states, be aware that within China, we have one country, two systems. We have Macau, Hong Kong, and mainland China, where we have different legal systems. And we already have such an arrangement in place, enabling judgment, civil and commercial judgment between the 3 different regions, we're talking about, in this context, between mainland and Hong Kong, between 2 different systems, we already have in place. The whole structure is similar to that of the Hague Judgment Convention, enabling civil and commercial judgment to be enforced and reciprocated between mainland and Hong Kong. So things that I think, from a practitioner standpoint, could be further improved is the interim relief. Because when we act for client, litigating in one jurisdiction where we know that there are assets in another jurisdiction very likely to be the enforcement stage, we want to go and attach that as assets in order to secure. At the end of the day, it takes time for a proceeding to finish in a adjudicating court jurisdiction. Now, that is lacking at present, both under the Judgment Convention as well as under the PRC HK arrangement, because Article 3.1b of the Judgment Convention and Article 4 of the arrangement expressly exclude interim relief as under the definition of judgment, and hence the convention or the arrangement does not cover. But in our arrangement, we have an Article 28 specifically say that, and hopefully it will happen soon, I'm looking at Solicitor General here, to talk to our mainland counterpart to have that work out and sign supplemental arrangement covering those aspects. And that is quick, isn't it? Thank you.
Thank you, Thomas. So as you have heard from Thomas, the Convention has addressed many of the issues identified by international litigators, so that it can be a very useful instrument. So I suppose when, Thomas, you advise your client, you will recommend them to use the judgment conventions when applicable, right?
Well, hopefully if our central government sign this first, right? Okay. Because at present it hasn't signed it yet.
Yeah, sure. We are about the time, but since we start our session late, so I think that we still have some time for question and answers. So I will now open the floor for questions or comments. Yes, that gentleman. So if you could briefly introduce yourself and ask your question.
My name is Li Tianyan from Department of Justice, Hong Kong. I have two questions for the distinguished speakers. My first question relates to the time limits for the judgment creditors to enforce a judgment under the convention. Is there a provision under the convention limiting the period of time for the creditors to enforce it? And I'm aware of, in some jurisdictions, there are time limitations on the enforcement of judgment credits, such as in Hong Kong. So when the receiving court is going to consider whether to enforce the judgment, would the time limits of that court of origin be taken into account? That's my first question. Second question is relevant to the employees and consumer disputes. In some jurisdictions, there are class action judgments. Is there a limitation under the convention on the enforcement of this kind of judgment? Thank you.
Thank you. I think I will address your question to two separate speakers. Maybe Ning can answer the first questions about the limitation period, and Marcelo, can you answer the second questions about the class action?
First, thank you for your interesting question. It's really interesting one. Not just me saying, because we have also discussed this topic at the diplomatic session. The Permanent Bureau has actually prepared a lengthy document on this topic. First, I want to say for the limitation period, what the convention already says, Article 4.3, says a judgment in order to be for the recognition and enforcement needs to be effective and enforceable in the state of origin, which implies that the judgment should the time limit for limitation period in the state of origin should be valid. So now we come to the limitation period in state requested state. So if, let's say, if in the requested state, we should just like refer to Thomas says. So when we talk about the court, we have the adjudicating court and the enforcement court. So it's the same for the time limitation period. For some countries, you also have time limitation for adjudication and time limitation for the enforcement. So what we talk about and what for the purpose of the convention is the limitation period for the recognition and enforcement has nothing to do with the adjudication part of the limitation period. So now we say, okay, and the time for the state of origin is valid, so it's within the period, so it's still valid judgments. Now it comes to the requested state. If the term of limitation period term is longer in the requested state, longer than the state of origin, so we do not have a problem. So that for the creditor, judgment creditor can just rely on the period and the limitation period and get the recognition and enforcement application in the requested state. But if the term is shorter in the requested state, which means when the judgment creditor brings the judgment to the requested state, where in the requested state and the time limit has expired. So for that case, then we need to refer to Article 13.1. The procedure for the recognition and enforcement it should be decided. The procedure should be decided by the law of the requested state. So in that sense, for the operation of the convention, then the judgment will not be available, will not be entitled to recognition and enforcement under the judgment convention. I hope my explanation is clear enough to clarify this question. Thank you.
Thank you. Marcelo?
Now working. Good. Thank you. Thank you for your question. To my understanding, the question is relating to the class actions. And this particular subject that we in Brazil call the collective actions. This was particularly studied by the Brazilian delegation. And to my recollection, this is addressed in the explanatory report and the comments for the first Article 1 or something like down there, or maybe on the definition of judgment also. So the outcome of these studies, and to our understanding of the explanatory report, is that the class actions are covered, the judgments on the class actions are covered by the convention, doesn't have any limitation on this, no limitation period on subject, on parties or stuff like that, just as it is ordinary in Brazil, the enforcement of such class actions tend to be individual after, if that settlement of adjustments is not achieved by the collective relationship, the actual enforcement tends to be individual, and thus it will circulate under the convention to our understanding up to now. Thank you.
Thank you. We can have one more question. Yes, this gentleman.
El Balti Baliq from Osaka University. I would like to make some critical comments about the benefits of the convention. So from the presentation of Dr. ZHAO, she explained that the convention has the benefit of putting certain order in the recognition and enforcement practice. And the reason is because there are a variety of national laws, different rules. So the convention will lead to kind of harmonizing these practices and predictability. I start with the second point, predictability. I'm not sure whether this predictability is ensured efficiently under the convention, because we ask about the burden of proof, you said, look at state law. We ask about limitation, said, look at state law. I can ask about automatic recognition, you would say, look at state law. So there are many aspects like this where when we look at the detail, and then the answer would be, look at state law. So from this point of view, I'm not sure whether this can be, the argument of predictability in this context is quite convincing. The second point is the practice of state, the practice of the recognition under state law or national law. So you mentioned about the attitude of non-recognizing foreign judgment. From my own research, I could identify only 15 systems, most of them from Central Asia, where recognition is not accepted. So only 15 states, including the Nordic countries. Reciprocity, it's true that reciprocity is included in many jurisdictions, but the practice shows that reciprocity is not really relevant in most of them, the overwhelming of these countries. Even China now is relaxing its reciprocity requirement. When we talk about the review of the minutes, anyway, so there are many conditions like this. And then when we compare between national law and the convention, and this is the purpose, the very purpose of Article 15, if I'm not mistaken, that is recognition of the national law, then national law is more liberal or quite liberal compared to the convention. So what is the, let's say, the reason for a country, let's say Japan? Japan has no convention on recognition and enforcement for judgment to enter into this kind of convention, knowing that under Japanese law, even what is presented under Article 6 as exclusive jurisdiction is not even an exclusive jurisdiction under Japanese law. So what would be, I mean, the reason for a country like Japan or a country with liberal recognition practice to enter into the convention, knowing that what was explained under Article 15 is that join the convention and still apply your national law. So this kind of argument for me is quite difficult to understand. So if you can provide a additional explanation, I'd be very thankful. Thank you very much.
Thank you. Would Ning like to respond?
Thank you for the interesting question. And when we talk about the convention, we said this is a private international law instrument, right? So what this private international law does actually is also the work of the the HCCH we are doing, is trying to build a bridge among the states on the private, so we do not deal with the substantive law matters. For example, what the user said, the limitation period of for the recognition enforcement is not within the mandate of the HCCH. It's also not the matter for the private international law to harmonize time limitation for each and every country. So that is what I understood is why sometimes we need to refer to the national law. What we try to do is try to build a framework. So you know when you have you want to submit application for the recognition enforcement, you know what's your outcome. So you still can predict what is the law is going to apply, even though it's not like telling you it's 2 years for the recognition enforcement, for the submitting the application. It's not telling you it's 2 years. Instead of telling you go to look Chinese law, law in Hong Kong, or Japanese law, so to go and see there what it says there. So that's what I would call is the beauty of the private international law. So it's going direct you to there rather than provide you the number. So that is the harmonization of the law. That's a different perspective. Regarding the second one about the states who has a liberal system, by joining the convention, will have to sort of sacrifice themselves to certain obligation granted by imposed by the convention, right? That's what I understood from your question. I think yes, joining the convention does require certain countries need to revise their law or modernize the law, whatever we call. But I think what the policymakers of the country, what they need to think is that will help to export their judgments to other countries. Not only like they are receiving judgments, they are also exporting the judgment. Exporting judgment, who is the benefit? Their nationals, their companies registered in their company. So I think that is bigger. The scope that we are looking at, bigger picture we are looking at. It's not just like revising certain part. And also, if we say that kind of sacrifice is only happen within the contracting state of the convention, not mentioning Japan has to revise the law for every judgment. It's only with regard to the operation of the convention. So I hope I helped to answer your question. Okay, thank you.
Thank you, Ning. Yes, I think that's important because we have to look at the convention as a whole. It's both requested states and also the enforcement as well. So it's not just incoming judgments. For example, some countries may have very liberal recognition enforcement of foreign judgment, but their judgment may not be easily recognized and enforced in some other jurisdiction. That's why this convention can provide very useful tool for reciprocal enforcement, recognition and enforcement. So I think that's very important. I think time is almost up. I just have one last question. I want to exercise my privilege as the moderator. And now we have heard some or many benefits of the conventions. And so if some countries would like to join these conventions, would the Permanent Bureau of the Hague Conference offer any technical assistance or any technical assistance program is available? So I would like to hear from the Permanent Bureau.
You know my boss is also there, right? two bosses there. And yeah, I see they're nodding, and we are more than happy to. We are more than happy, and we will provide any technical assistance to facilitate the countries to join the convention. And we are looking forward to working with all the stakeholders, judges, policymakers, practitioners, and academics to for the sake of the cross-border business, cross-border dealings. And that's it. Thank you.
Thank you very much for the offer, and I'm sure the regional office in Hong Kong will be happy to offer assistance as well. So maybe I will conclude these sessions, and could you give us a big applause to all our panelists?